Thank you very much, honorable esteemed panelists, Professor Rao, and other esteemed dignitaries who are present here, my old friends and new from Nalsar, and dear students. First of all, I would like to thank the IPR chair for having me here. So the topic assigned to me is on the question of employability of IP law graduates. Well, there are no IP law graduates as such, they are law graduates, but those who are interested or deeply interested in this field called intellectual property. So before we move on to the question of employability and market readiness, I just wanted to briefly track down the or the scholarly kind of works that have been done in the area of intellectual property. Most of you might not know that intellectual property education in India may seem to be very new, but definitely the scholarship in relation to intellectual property is not new. You have one of the oldest, what you call, commentaries on intellectual property, written by a Bengali barrister, Prasenjit Sen, and he published a book called The Law of Monopolists in 1920s, and that broadly discussed the colonial copyright law. And since then, of course, in between, and there is another interesting fact that the book Terrell on Patent Law. Patent lawyers must know. It is actually co-edited by another what do you call English sounding name. I can read out the name if you know, because I have to also tell you that he is an Indian, by the way. And so you have Thomas Terrell and Kev Edwin Shelley. Terrell and Shelley on Law of Patents, 1952. Okay, this is the 9th edition. 9th and 10th editions were published by these people. And interestingly, his name is Krishto Kumar Banerjee. And Mr. Banerjee, an Anglophile, perhaps converted, and then was called as with a new name, Kev Edwin Shelley, and is a co-author with the Terrell on Patent Law. So there is a deep history to what we are talking about in terms of IP scholarship, at least, if not education at that point of time. But on the question of IP education, I think Professor Bakshi's article in 1986 is a little bit instructive, where Professor Bakshi has remarked on the phases of IP education, and he said that although there has been a vacuum, but by 1980s onwards, and perhaps because of the Uruguay round discussions in the at the proposed WTO at that point of time, 1986 was the Uruguay round. There were some movements into creating what you call network of scholars in the developing countries, and that phase I call as Professor Gopalakrishnan phase, because he's my professor from Cochin University, and they were the ones who were at that point of time, working on these issues at a very young age, at the level of assistant professors, and they were trained, and they also had later contributed to post, TRIPS negotiations in the WIPO, etc. So there is fair amount of history of what we are talking about in terms of IP education. Now, why is this history important? Is because there are things that have radically changed since this kind of period that we are talking. Primarily because today intellectual property is not a subject where it is purely what do you call engaged from a scholarly perspective, but it has become one of the core areas of litigation and prosecution services, right? And that is where the question of employability of our law graduates, particularly those who are interested in IP, comes at the forefront. And we have achieved mixed results. How do I say that? I don't have a survey to tell you, how many law students, spoke to me about it. But the feedback that we generally receive from practitioners tells us that, there are serious gaps in the learning that we engaged in the law school curriculum, and there is sufficient amount of bridging the gap that the law firms do by requiring them to really sit and do the application work, for example, if it's prosecution related. But in litigation, there has been some, what do you call, there have been major leaps where I have seen that young, what do you call, law graduates, particularly from law schools, have been eager to litigate cases, including, pending disputes like, of public interest like Sci-Hub. For example, one of NLU Delhi's graduates, very young graduate, is working on this matter with some senior. So it's not that, we are completely off the mark, but more needs to be done and more can be done. So where are we, or I won't say lacking, but what are the major limitations that we can think about in relation to IP education? One of the major limitation is the focus on information rather than learning. So our classrooms, particularly the survey courses, and I've been thinking all about how to reinvent the survey courses. Our survey courses, what is happening mostly is we are doing the case law approach and we are conveying the jurisprudence, and in the examination at some point of time we ask them really very good analytical questions, but that's where it stops. Perhaps one of the suggestions that I have seen from professors not in India but professors who are teaching abroad is, when I discussed this during one of my earlier engagements with them, they said that survey courses are some of the boring courses as far as the teachers are concerned, but very, very essential as far as the students are. So if it has to be a mix and match where the students and the teachers' demands can meet, then perhaps what we can do is to have a survey course, have brief descriptions, descriptive parts, but in one contemporary area. For example, if you're teaching a survey course on copyright and you want to teach fair dealing exceptions, there are so many exceptions in the Indian copyright law. How many are you going to teach, right? So maybe what you can pick then is the most recent one, like say TDM exception, which is the most controversial, which is where legislation is going on in Europe, US, and pick it up and do it just straight vertically, rather than teaching and giving importance to all the exceptions horizontally. So this suggestion I have not tried, but I think there needs to be some amount of consensus and discussion within the Indian legal teaching community, primarily because our law students, when we give them readings, they don't read. In the West, when readings are given on general attributes of say fair dealing, students would read it and then they would understand the general bits and pieces, so that we don't have to go deep dive into all the cases and the nuances, etc., and take the ones that are the most controversial or the most. So I think this problem of information and excessive information in our survey classes, IP survey classes, is something we need to rethink about. The second one, and for this I think Professor Rao today suggested that we should start the IP teaching workshops, and perhaps discussing this amongst ourselves and then trying it in a beta deployment mode or a beta testing mode with some students would be at least in some law schools, would be a good idea. The second point I would want to convey is regarding the issue of working in silos. So now what is happening, from what I understand, especially within our law schools, I'm not speaking so much in terms of law colleges which are located in universities or even in technical universities, but law schools are, I think former Prime Minister remarked that they were islands of excellence. They are islands of legal excellence, but intellectual property as it is, as you may know, it's very, very multidisciplinary, interdisciplinary, right? You need to really understand the nuances and at least have scientific temperament, even if you don't have a scientific degree to understand patent law, for example, right? So to what extent are we fulfilling these kind of requirements wherein real hand technical expertise can be brought into the classroom? I try and do it. I don't have a science background, but I do patent law. So what I do at times is to get practitioners who have a deeper scientific knowledge about the subject, because the legal knowledge is all there that we can always impart in the classroom. But the scientific knowledge, I think there has to be some kind of transparency among the faculty members to say that yes, there is a deeper scientific background that we cannot convey to the students in very easy words, and you need people, particularly those who are either patent agent or in patent prosecution or even in litigation, those who do hardcore science. They are the ones who would really want to come and teach. For example, if you're doing Monsanto's BT cotton dispute, if you don't understand what the technology is, you will never be able to understand what the decision is. You will just think that whatever the decision is was such a fantastic decision, right? You would really have to know what is a gene construct, how is the gene constructed embedded into the plant cell, etc. And those are very, very technical, but which can be understood in simple terms. And if that can be brought in the classroom, whichever way possible, I think these objectives of interdisciplinary education can be met as far as education is concerned. Because that's how you develop employability, because then you know a bit of what the facts, clear facts of the dispute are. Because in intellectual property cases, particularly in patent cases, facts of the dispute are often lost in the classroom. This is what, in my own experience, I have noticed. And the humble attempt is to then, try and bridge that gap. The third thing, and I will stop with this, is that there is some amount of, I think, inertia within the teaching fraternity and also the student fraternity in terms of what is really expected out of the classroom environment. I wouldn't say inertia, but I think there has been a, what do you call, a kind of a trust deficit, or maybe just general confusion. The confusion is that intellectual property is a property right, right? And by the time you are in your third or fourth year, you are already, sort of, I wouldn't say indoctrinated, but definitely you have build your own view about what the property regime is. And you must have had some, classes in sociology, political science, and other areas, which create a kind of a smokescreen around you, thinking about property, and particularly intellectual property, in a very different terms when compared to what you hold in your hand, like a smartphone or a laptop. And the problem seems to come in the class every now and then again, where students end up raising policy questions. Policy questions, for example, what do we do with access? And this is a fundamental problem with intellectual property, that the whole idea that you have intellectual property minimizes access. But if you keep on asking those questions from policy-based perspective all the time in all the classroom, that doesn't work. So I tried one method to avoid this. What I do in my first class is what is called as a turncoat debate. In the turncoat debate, what I do is I ask students to just randomly say that they are either in favor of intellectual property or against intellectual property. Because by the fourth year, as it is taught at NLU Delhi, they already have made up their mind by reading either Spicy IP or either IP Watchdog or either, and you have fairly, in my estimation, 80% of them are anti-intellectual property and 20% are pro-intellectual property, which is fair enough, fine. But then what I do is, in the turncoat debate, I ask them to argue otherwise, and then give your reasons as as logical and rational thinking individuals as to why you think your position is, and that really pushes them to rethink on their assumed biases of whichever way possible. To illustrate simply, many of us in India think that the rationale for copyright law in India is a private property right, okay, because it's a property right, or enriching the public domain. The whole idea that copyright law is not a private property right, but the whole idea is that the public policy basis for copyright law is that after the expiry of the copyright term, there's a huge public domain created, and perhaps we need lesser and lesser terms of copyright law and minimizing copyright law's scope, okay, and create a vibrant public domain of quote unquote ideas and works. However, if you go through the parliamentary debates, the real rationale for intellectual property in India was perhaps illustrated, at least in my opinion, by Ramdhari Singh Dinkar, our national poet. And he said that why we need copyright law is because copyright law is so fundamental to democracy that without it, we would have to, we have to rely on state patronage all the time. And with state patronage, there is an element of constant bias and lesser dissent and free speech, right? So copyright in that sense is an engine of free expression. And he gave a very good example of his visit, then recent visit to Russia, and he was a parliamentarian then. And he said, when I visited Russia very recently, gone are the days where people like Dostoevsky used to write for very foundational works. Now, because of state patronage, Russian writers have stopped thinking. They are writing, but they have stopped thinking. And he said that should not happen to India. And that's why when we got in our new legislation in 57, one of the bases you can see of the copyright system is expressed through his views that it could be anything. You call it a property right, you want to call it a public domain, but at the end of it, it serves a very strong utilitarian value of democracy and free speech, right? So then we don't need to get into these what you call public policy debates all the time as lawyers, because there is a place for that, there is a time for that. Perhaps we should then get back to the law and see the nitty-gritties of the law, maybe from a critical perspective, but there is only so much you can do always in the class. So these are some of the few observations that I had, because with this I think we can raise the employability, primarily because then you are not stuck in the rut of thinking about IP. It's good if you want to become academics and scholars, but it's definitely not good if you are preparing yourself for the market. Preparing yourself for or employability really means that you need to know the law in and out through internal and external aids of interpretation, right? So that's where I would stop, and thank you one and all. Thank you very much.
Maybe also if there are one or two questions you can take. If anybody has a question. No, thank you. I just want to say a point here that you very rightly pointed out that we need practitioners to come, because that's a different field. And I'm very proud to say that Professor Bharati, who is sitting here, runs a course. That course is going on for the last 24 years on patent law, where most of the resource persons are not academic. Okay? They are practitioners who come.
Academically minded practitioners.
And he's running this course successfully for maybe, I think we are now 24 years.
Yeah, I took over 2 years back, but before that, Professor Vivek was.
And it's a very, very successful course, and it has a good currency in the market. It is being, many of the corporates do value that. And what has that course given me is, wherever I go, I find students. Any corporate office, anywhere, in fact, even overseas.
I think perhaps NLU Delhi, we need to emulate you, what you're doing here, because I think what happened with Nalsar Pro and how, what you were speaking about the course has done, I think has a lot of learnings for us.
Okay. And
that's why we need that IP teaching workshops to discuss about this more.
Yes, and we would have trained more than close to 20,000 people in so many years.
So can we then conclude? Sure. Sure.
Thank you, sir, for that. And that's definitely something I guess we all will introspect as young students studying IP. Professor Sarkar, would you please give the memento to Dr. Yogesh Bhai?
And I'm also happy to say that this is a GI.
Thank you very much. Thank you. I'm very sorry. Both of us have to leave at the same time on catching the same flight. So I thought, it's the right time to leave because we have flight at 1:15. Thank you. Bye.
Thank you, everyone. Moving on, we will be having Mr. Subhadeep Sarkar speaking on the topic of challenges of employing fresh IP professionals. Mr. Subhadeep works as Vice President at Cognizant and manages intellectual property, technology licensing, legal operations, and corporate affairs of the company. He serves as the board of directors for several APAC subsidiary entities of the company. Mr. Subhadeep has extensive work experience in the field of technology, IP, and legal affairs. Some of his core competencies include managing multi-scenario IP strategies, IP risk, and IP compliance management, driving product IP strategies, licensing and commercializations of IP, mergers and acquisitions, managing complex deal negotiations, pricing and valuation of technology, technology transfers, among other things. Mr. Sarkar, we're very excited to hear from you.
Thank you so much. It's a privilege to be here, and special thanks to Anindya. Anindya has been my teacher in Nalsar, as well as my boss in Infosys. So he had worn multiple hats, though we are not related just because I have a Sarkar. I'm also a Sarkar. And that has been, we have actually, on a funny side, on a lighter note, we have shared, panels, many, I think, in hundreds. And we have a common friend, Sanjay Sarkar, who is also an IP professional. There has been instances where all three of us are in the panel in a conference and everybody says that are all of you related? Okay, now coming to the challenges of employing IP professionals, before I get into the challenges, which sounds kind of negative, and my intent is not to make this session negative, saying that, oh, fresh IP professionals or fresh lawyers have a lot of challenges, so don't hire them, or, et cetera, et cetera. So it should not be a kind of negative. So, but at the same time, obviously, there are areas of improvement, and we are going to talk certainly on those areas of improvement. But before I do that, I think it's important to know for the audience in terms of what do an in-house IP professionals do? Because if you have to understand challenges and the reasons and gaps, you will have to step back a little bit and try to figure out what happens in a company, in an IP department, what are some of the activities, et cetera, et cetera. So if I briefly summarize this, in patents, most of it you may be aware, but just to highlight a few things, if you look at patents, you have search, prior art search, or you call it novelty assessment, patentability assessment, et cetera, is very important. And then, of course, once that is done, then you have drafting, then you have prosecutions, responding to office actions, then you have a filing and docketing process, you have infringement checks, which also is sometimes called as freedom to operate, or those kind of analysis. FTO is a very common terminology in the corporate world. You have landscape and competitive analysis in terms of using patent as an information to figure out what competitors are doing, what others are doing, what is the technology trend, where is the gap, where is, which is a crowded domain. So all those analysis forms the landscape and competitive analysis. Then you have patent assertion or enforcement, if you have to assert your patent rights. And then you have, if somebody sues you, then you have to, prepare yourself for patent litigation, support, etc. And then overall administration. So this is on the patent world. Similarly, on the copyright side, you have a filing, you have dispute, you have notices to serve, or even the copyright notices that you should put in your documents or your software or your web page, etc. All the terms of use all will fall under that. Trademarks, again, it could be a search that you are doing before filing trademark, or you are trying to sort out a dispute, or there's an opposition and you're trying to prepare, or it could be maintenance, etc., etc. IP portfolio is a very big chunk of work that happens within corporate, and where it could be portfolio analysis that you try to do. You try to figure out that you have a good portfolio of patents, but you don't want to continue with all the patents. You basically, try to find what can be abandoned, because patent process is a expensive process. And when I say IP portfolio, I'm just giving example of patent. It need not be only patent. It could be the other IPs also. And then you have an asset management, you have IP mining and disclosure management, which is about how to find out what is inventive when a technology is, or a technologist is working on a particular technology. So that is called as IP mining. And then you have administration, risk management, you have joint collaborations, all of it forms under the portfolio management. Then you have audits, which is another area, which is about conducting audits, implementing the IP audit process, or even audit can be linked to portfolio management, where you basically try to audit a process to figure out what are the valuable IPs, what are the IPs that can be abandoned, etc. Trade secret, another area which not every company they do, but large companies who have trade secrets, there is a process around it, and the process is what protects, right, in trade secret. So therefore, if you have a weak process, then there is no value of trade secret. You can shout it loud that everything is trade secret, but let that information open to all your employees doesn't make it a trade secret, right? So you will have to have a process to protect it. You won't get that kind of a strong right as you would get in the other IP acts or IP laws. And then you have a whole lot of activities around IP processes, which could be formation of a policy, which could be, process relating to training, building that IP culture, or budget, or even IP agreements. In terms of, when I say IP agreements, it could be all the IP related clauses in any contract, or it could be even related to the IP provisions in an employment contract. There could be a lot of disputes. How do I protect inventions in my employment agreement? What about the prior invention that a person would have done before joining the company? So there are a lot of complexities around IP agreements, IP clauses in different agreements. And then you have to, have some incentive mechanism for inventors. So there are a lot of work that an IP professional needs to do within a company for the benefit of employees in and around the IP, branding, culture, and incentivization. Then there is a huge chunk of work on the M&A support, which I think is extremely important, whether it is doing an IP due diligence before M&A, or when you are integrating IP, integrating a company post M&A. And then licensing and commercialization, very huge chunk of work happens on the IP side, whether it is IP licensing, or it could be determining the licensing models, signing a contract, negotiating a particular deal, identification of the various risks that are associated in a commercial deal or a licensing model, mitigating those risks, all will come under IP. Now, while these are some of the activities, or I would say a very high level activities, of course, not that all companies will have the same model. There are some companies who may focus on a particular bucket more than others. Some companies may not do everything. It is all need-based. But the question that you should ask yourself is, how much of this is taught in your course? That is a question that I think you should, as a student, or even academicians should ask, how much of this is taught? I don't need an answer, but it is a food for thought for you. Now, let's look at talent sourcing. I'll connect all these 2-3 slides that I have at the end to bring what challenges that we're talking about. Talent sourcing is important because what is important to know is, first slide had what do an IP professional do. In order to get those done, where do we hire from? Now, it could be hiring from, let's say, a law college, a fresher who may be interested to do IP, but in certain cases, the student may not be sure what to do. Should I get into contracts? Should I get to, because you have to understand the in-house legal department in any company, 70 to 80% would be contracts, typically. And the remaining part will be what is left over. So sometimes the students may not know, they may join for a brand, they may join because they need a job, etc. So there is a portion of the students who may be interested in IP, and that is one source. It could be a lateral from law college. The lateral, what I mean by lateral is that they are not really freshers. They are freshers, but they are not through campus hires. I mean, there's a difference. One, I go to the campus, I sit on the campus placement and get it. Another is that I can hire a fresh law graduate directly, externally, so that we call as lateral. Then IP professionals also come as a technical, source. For example, they are not lawyers, but they are technically good and they may be interested to know about IP practices. That is also one source that we hire, and those people are very good, especially on the patent side, because there we obviously need technical people. Then we can have experience lateral, where we, people may have, good amount of experience in a particular technical field, and they are interested to know about IP. Then we have experienced law graduates. Now, they are not campus freshers, law graduates. And some of those law graduates may have experience in IP. So they are good fit, right? And then you have experienced law graduates who may not have experience in IP, but they are willing to try in IP. So they would have done, we get a lot of candidates where they say that we have done too much of contracts, now I want to move into IPR. So give me an opportunity. So I've learned it, but I've never practiced it. Now I want to practice. And then you have specialized IP law schools who are more of specialized on IP laws. Or it could be an internal movement that can happen within the organization from one department to another. There could be somebody who is a security expert and technically very strong, or very strong in AI technologies. And that person may say that, hey, I can actually look at inventions that are coming on the AI side, and I can actually help you guys draft the specification of a patent, etc. So therefore, the point that I'm trying to drive here is that you get different set of people having different specialization and need. And therefore, the work allocation or the work that is expected needs to basically look at the background, the specialization of these people to meet what I talked about in the first section, first slide. What are the key expectations from a company when it comes to the IP work? I've bucketed into 4 broad categories. One is passion for technology, especially if you are working on patent law. Now, when I say passion for technology, I'm not saying that you should be technically very sound. That is not the expectation. The expectation is that you should get excited when somebody is talking to you about technology. You just can't say that, oh, that includes, probably maths, and I'm very weak in maths, I'm running away. Okay, let's change the topic. That is not, you are not expected to become an expert in technology. You are not expected to know the technology, but you are expected to understand what the other person is speaking and probably try and use a similar language to have that conversation. Because if your client is seeing that you are not interested in the conversation, you will lose the client, right? Whether you're doing a practice or you're working in-house, etc., etc. That is the first, expectation which is required. Second is business alignment. Business alignment, what I mean by business alignment is that you should understand what your client is actually doing, what does he expect, what is the main objective, where he wants to go. The reason is it's not about just it's about asking the right question, saying that, okay, you have come to me to file a patent application. So I'll draft a patent application, I'll understand your invention, but tell me, what do you want to do with that invention? Where all you want to go? Is it that you want to just focus on India market? how are you trying to commercialize? Because these questions are so important, because when you, let's say, draft a claim of the patent, you will have to understand, should I be protecting the method? Should I be protecting the system? Should I be protecting the process? Because if you don't have the business alignment and the business answers to the business questions, you will never be able to do a good job. Drafting of the patent is not only a science, art, and the legality involved into it, but it's a combination of everything. And that brings me to the third part, which is forward-looking, proactive, and analytical. Especially on patent and IP laws, you have to think beyond what the inventors are thinking. Because if you don't think, and you're just listening and just copying whatever he's saying, and you just translate that. I've seen many patent lawyers saying that great invention, very good. Actually, the person has not understood. The lawyer has not understood. So the lawyer's next question would be, can you send me all the documents that you have? Okay, I'm sure you would have created a lot of documents. You would have probably written a draft paper, sent it to me. That is important because you have to read, but there's also an intent that could be that I'll copy paste and put it in the specification. My draft is over, right? That is not expected. You are expected to know the subject, you are expected to ask the right question, and then you start working on it. And the last but not the least is non-transactional. What I mean by non-transactional, this is not just relating to IP, it is relating to any practice that you do, whether in-house or whether in a law firm, etc. It is not that you are running a stationery shop, that I'm standing in the stationery shop, I have a lot of items, I'll wait whole day till I get my customer. I get the customer, he says that give me a pen, I give the pen, take the money, and my job is done. Lawyers' work is not just transactional. The moment you start thinking transactional, you don't add much value, because the client will see that what is the value that you are adding. Okay, right? Look at it from a stationery shop example. If I just give the pen is one scenario. If I say that, hey, can you write it? Actually, your grip may not be, because the grip changes with person to person depending on the finger. So why don't you try? If you don't like it, I'll give you another pen, right? Try all the grip till you get the best grip. Look at the reaction from the client side. That person will say, he's actually asking me the right question. He's adding a value, and he's not just a shopkeeper, right? Therefore, when you work with your client and inventors, you have to go beyond it. You have to say that I am a partner trying to help you. We both will, make sure that your invention is so nicely drafted as a patent and is protected that you will have no problem. And I will tell you that, there are also certain things that you are doing. We'll file multiple patents later on, in addition to this, and I will help you. That person is able to see that, yes, you are working as a partner. That partner relationship should come between a IP professional and business. And that is very, very key to get the confidence. You have to remember, when you work with technologists typically, they are very impatient people, right? Especially if you are working with, mad inventors, the moment they find that you are not interested, you are not able to understand, you don't show any interest, you are not adding any value, they'll walk out. They're not bothered. Because many cases you will find in your career that a technologist and an inventor will be more keen in publishing a paper than to file. Because that has a lot of advantages as well, especially in research institute, right? Now, your job is to actually ensure that they file a patent before they publish. Sometimes you will have to go beyond your normal duty to convince them why it is important, why patent. So therefore, talking their language, showing that interest, building that partnership attitude will actually help you to be a better partner. My last slide, areas of opportunities is what I call, rather than really a challenges. Now, in the IP field, the 4 blocks that you see, the 4 red, high visibility, business impact, external facing, and working on advanced technologies are some of the advantages when you take IP as a career. Unlike, the typical, contract lawyers, let's say, lawyers who work on contracts, etc., I have seen that, lawyers working on IP, they have a little higher visibility, because what happens, they get to work a lot with advanced technologies, get to work with senior level management resources, leadership, etc. So there are advantages of working on the IP field. Not that I'm trying to force everybody to take IP as a career, but this is what the practical scenario is. Now, in terms of 4 different areas which are important: core competency, business alignment, personal, and your growth. Now, core competency, I've touched upon some of this while I was explaining the other slides. Knowledge of international laws is very important, because you just can't say that I'm very, very conversant with the Patent Act and that's good for me. No, because any company that you go, they are all international. International means that they have products which they have to license it out to other countries. There are also license in that you would do, right? You cannot have just your core technology. Today, all technologies are dependent on third-party technology. So, knowledge of international laws are very important. Connected practice. What I call this as connected practice, because it's just not about patent. You should also learn how these are connected to other areas of practice. Just to give an example, I talked about FTO analysis. What does it happen in a freedom to operate analysis? You are basically trying to figure out that if your product, before it gets into market, have you checked whether there is a possibility of somebody asserting their patent rights against you for the product, saying that, hey, I already have this patent, so you infringe, your product infringes on my patent, so let's talk about revenue sharing or licensing, or they go into litigation, etc., right? So you do an analysis to really figure out what is the patents, third-party patents that may trouble you in future. It's not that it is a foolproof mechanism, you could do it, but it's just a risk management tactic. Some companies do it, some companies may not do it for different valid reasons. But the point is, once you have got the analysis done, and you figured out that there may be a potential risk, it may not be that they may sue, but there could be a potential risk. Now, when you're getting into a license agreement with a customer for the product, the input of indemnification or limitation of liability, those clauses that you would negotiate in a contract, is very much dependent on the analysis that you would have done. Because if there is an element of risk, I would certainly want to limit my liability to, or give, instead of having unlimited liability, I'll have a secondary liability cap. So the point that I'm trying to say is that these inputs, it's not silo, it's connected to contracts, it's connected to the M&A part that you do. So different activities are connected, including different areas of practice. And then procedural aspects of IP, extremely important. It is just not the law, but the earlier speakers also talked a lot about the practitioner's view on IP. Technical know-how is not about knowing the technology again, it's about having that mindset to read. And communication is extremely important, because in the IP world, you will end up communicating with very senior people. So you should know, I'm not talking about the language capability, I'm talking about what to communicate, how to communicate. Those becomes very important. Business alignment. Again, business knowledge and technical language, non-transactional, which I've already talked a lot about it. Connecting the dots with business, R&D, sales, commercial. Because see, in any particular deal, whatever work you do on IP, you have to understand how this is connected to business, how this is connected to sales. You have to go one step beyond for any transaction that you do. See, if a lawyer is working on contracts and contracts review, I have seen in my team, there are many people who will do review, but the moment it comes to, let's say, the pricing part or payment terms or delivery, they'll say, oh, this is for business to review and comment. Please don't do that, because you have to understand that as well. You may not give valuable input on this, but it is important for you to know those, so that what is the implication of those for other clauses becomes very important. And then building the trust factor with inventors that I've talked about, and risk identification and mitigations. Overall, what are the risks, how this can be mitigated. Don't leave at only risk identification. The client is also expecting you to suggest how those can be mitigated. And then personal side, passion for technology, passion to read and having that curiosity. I think one of the speakers talked about it. Reading is so important because you will end up in the IP practice reading because that's what you will anyway have to do. Having the analytical mindset, communication, dealing, proactive, these are all what we talked about. And then finally is maturity and learning curve, job rotation. What I mean by this last bucket is I've seen many lawyers who will start with an IP career or in between take an IP career and then after 6 months will come to me and say, I think I've done enough now, let me move to litigation support. That sounds very interesting, right? And then after 6 months, they'll say, I think I'm done with litigation support now, let me move to real estate, I want to do something on leases. IP is so vast, you really cannot move so quickly. Job rotation is good as a career option that you want to move between practices, but it's so vast IP that you cannot be impatient. You have to give time. And if something requires 1 year or 2 years, you will have to put in that time. There could be situations where there are many people sometimes say that I've joined IP because normally IP lawyers are paid more than typical contract lawyers. That's why I'm moving to IP. But that should not be a reason. If you are trying to build a competency, do it properly because that's the only way you can reap the benefits later on. So I think with that, I'm not sure if I have overshot my time, but this is all what I wanted to share. And thank you once again for inviting me. I'm open to take questions. Yeah.
So you mentioning about how probably an overall understanding. I just wanted to understand your opinion whether, as an undergraduate student, it would be better to start off as a general lawyer, having an overall understanding, or would it be better to start off directly in the IP profession?
See, both are fine. You can do either of this, but it depends on, let's say, your interest is very important because IP is a very specialized and niche area. There is nothing wrong in starting with IP, and you can always move. It is not that just because you started with IP, you cannot move to other areas. So both I have seen and both works very well. But the decision should be yours based on interest. The decision can also be based on the company. That there are some companies where it is IP heavy company because they survive on IP. Their bread and butter is the IP business. So starting IP on those companies would be better. And if you're going to a company where IP is important as a practice, but it's not the priority, then starting with IP might demotivate you. So sometimes it's a decision of your personal choice, your passion, as well as the company.
And so on that note, in my very limited understanding and experience, what I have come across is, say, patent lawyers. They usually always have a technical background. So even if we say do skill development and keep upgrading, trying to understand the technology, how could we probably keep up or match the people who have a science background or a STEM background?
No, that is usually what is seen, but I've also seen there are many people who pick up things very fast, right? So if you are interested, it's end of the day, this is very important for you to know that you don't have to be an expert. Suppose let's say you are working on a AI invention, artificial intelligence inventions. Now, you don't know, may have a commerce background or humanities, whatever it is. Now, when you're talking to the inventor to understand, your first job would be to go and read prior to the meeting. Because the moment he or she starts using acronyms, you should know at least what they're talking about, right? Now, then after that, you take the notes, you go back and read, and then you may find it interesting. It's not rocket science. Whatever technical knowledge you need to know for the purpose of drafting, that can be done even by a non-technical person. But you should always check whether is the technology or the talking to the inventors exciting you? If it is not, then don't pursue, because then it will be boring after a few drafts. Then you have to probably, I've seen they move to copyrights or trademarks, even if they want to continue an IP. Law part.
Full lifetime. Can I give you a serious answer?
No. See, you can move, and I have seen many people moving as well with your background, and there are many people who are much better IP expert today without having a law degree. So for you, I think movement is possible. You can, but it will take time. It is not that you can suddenly understand the legality of IP in 6 months' time. But it is very much possible. You can, but again, for science people or technical people, they should also have a bent of legal mind also. If you feel that, oh, this is too boring, too many, sections to remember, etc., then it may not be good. But your knowledge of law is important. That can be acquired, yes. Anindya, you want to add something?
Oh, I have a question for you.
Oh, okay.
In a very short sum up, if you have the current legal education in India is governed by the Bar Council. Okay. The syllabus, everything is fixed by the Bar Council, and law institute, law colleges, law universities are struggling to match up to that. Okay. And in that present scenario, there are some institutes which offer extra electives for such specialized programs. Now, electives are not mandatory, although it gets represented in your mark sheet. So there is not too much scope for the practicing part coming up into a student's life, unless somebody is doing a proper internship somewhere.
Correct.
So you have some tips and suggestions for students?
So I think what is important is, one is, of course, internship is an option where you can join IP companies and IP law firms, but that is very limited. And in a company, the internship model becomes even more limited, because unlike a law firm where they have the standard model, they know how to utilize, but some companies even struggle to use interns properly because the period is very short. So one thing which is important is to have IP practitioners come and take specialized sessions. And if you are interested, you have to attend, because that's very important from a college perspective, to invite practitioners, let them take sessions, join seminars wherever possible you see on IP. There are, at least 100 seminars happening in India every year, more than that. See what best can be attended. Those aspects are, I think, very important.
Thank you. So another thing is that can the students approach you for internship?
Students can definitely approach.
And get kind of a little bit of additional exposure?
Yes, that is possible. So so interns who join us, I mean, there are different models, and on the IP side, I think there are specialized areas that we focus for internship, and we have identified those specifically, keeping in mind that the period will be very short, but we have focused.
They don't have more than a month.
And I think what is important and what I try to focus is, let them talk to inventors, have the business conversation, because that's very important. You end of the day, you have to talk to client after you pass out. So some programs are there. I'm sure there are many companies who also do different approaches on how to mentor interns. But yeah.
Thank you. At least, things have, when we were working together, we never entertained any intern, at least in my team. but in the initial stages,
Yeah.
for the most part of my practice in corporate life. But then gradually we started taking some of them.
Thank you so much.
Thank you so much, sir, for your insightful talk. Professor Sirkar, if you could please give our memento to sir. Is the PPT on? Yeah. You have sent it, yes, sir. Our next session is by Dr. G.B. Reddy, speaking on the topic of are there changes required in IP academia to get better IP professionals? Professor G.B. Reddy is the IPR Chair Professor at Osmania University. Dr. Reddy has practiced in the High Court of Andhra Pradesh for about 7 years before joining the Faculty of Law at Osmania University. He has authored 20 well-received books on law, including Women and Law, Intellectual Property Rights and Law, Copyright Law in India, and so on. At present, he is also officiating as Joint Director, University Foreign Relations Office, Osmania University, and as Director of the Legal Cell of the University. He was appointed as a member of the General Council of Nalsar University of Law, Hyderabad between the period 2011 and 2014. Dr. Reddy, we're extremely excited to hear from you. Thank you.
Very good morning, Professor Anindya Sarkar, Professor Sarkar, and my learned colleagues and dear students. I'm happy that most of the things which I wanted to cover, they have already been covered, most of them. So I'm left with a few points to make out. But before I make a formal presentation consisting of a few slides, let me tell the young students here or the young professionals that the IP teaching in India has not been so satisfactory for the last so many years. Reasons are many. In fact, let me share an experience of mine. When we studied law in late 1980s and early 90s, 91 I graduated as a law graduate, IPR was not a subject at all. But there was a good grounding for the study of intellectual property for those who were interested. I keep on sharing with my students that law of torts is the good launching pad when we talk about injurious falsehood, when we talk about passing off. That's nothing but, the beginning of the learning of intellectual property. When we talk about the property marks under Indian Penal Code, again, there is a nexus with the trademarks. Of course, there is a distinction between trademarks and property marks. When we study or learn the procedural aspects under CPC, if you go through Mullah's book on CPC, you will come across any number of IP-related cases. But IP was not taught as a separate discipline. And I remember 1998 or so, 97, when we entered the teaching profession after about 6 or 7 years of practice. And there was a program somewhere in National Law School of India, University of Bangalore, a 3-week program, a refresher course, and 1 week was totally dedicated to intellectual property. And there were people like Professor N.S. Gopal Krishnan, then even Mr. Praveen Anand was one of the resource persons, I remember. So the interest in intellectual property was rekindled for the young teachers. But today, it's totally different. We have intellectual property rights or intellectual property law, which is taught at the UG level, at the postgraduate level, and it is also taught in the schools of technology, engineering, management, even sciences, forensic science, so on and so forth. But very unfortunately, it's not a compulsory subject as per the syllabi prescribed by the Bar Council of India. It is an elective, but it is for the academic institutions to make it a compulsory subject. We did that in Usmania University for the last so many years. Be that as it may, the challenges in the intellectual property education are increasing day by day for various reasons. Maybe technological challenges, the difficulties in understanding the procedural aspects, managing the enforcement, the typical management aspects, all of them are not taught in the curriculum which is designed by the respective law schools. Maybe some of them are doing very well. If you talk about the patent education, it is given much focus in Rajiv Gandhi Institute of IPRs, IIT Kharagpur. And if you are talking about a certain, greater focus on intellectual property rights and advocacy, we talk about CIPRA, National Law School of India, University, Bangalore. And if you talk about some of the niche areas, certain institutions are better known for that. But the standards are the expectations. Both of them are yet to be met in the general teaching of intellectual property. And another important problem, intellectual property rights should not be treated or is not treated exclusively as a law subject. Of course, we talk about rights, but intellectual property is a multidisciplinary subject. So we talk about the management aspects, IPM, Mr. Sarkar was trying to mention about that. We talk about IP audit, it's an economics related aspect. Police also are concerned about IP vigilance. Then customs authorities, they are equally concerned about copyright protection and counterfeit goods in the channels of international trade, imports, exports, so on and so forth. Therefore, to confine it only as a subject of law will not do justice either to the students or the professionals or the field in general. Once again, another important aspect, intellectual property law also is not isolated. It is related to every discipline of law. Nobody can say that I am an IP law expert because it is related to contracts. Again, pointed out by the previous speaker. We talk about IP crimes today. There is an increasing fascination for, studying the counterfeiting of goods. Even our, sponsoring agency, the Ministry of Industry and Commerce, it has been conducting number of, lectures and awareness programs even in the police academies and judicial academies on this particular aspect. And let me, give you one of the latest examples. I think most of you must have read a news item about yesterday's Delhi High Court's, interim order, an order which refused the plea of Sci-Hub founder. Remember, and Sci-Hub founder, who is facing a litigation before the Delhi High Court for infringement of copyright in several of those articles and papers which are shared free of cost maybe at the cost of violation of copyright of those publishers. She says that there is no ownership of copyright vested in those publishers because they have not paid anything to the authors. There is no consideration, there is no contract, there is no assignment. Therefore, they don't have any right to sue Alexandra or Sci-Hub. Fine. But here comes the jurisprudence. Here comes the contract, law of contract. Is it an agreement without consideration? Or is it a question of surrender of the copyright by the authors in favor of the publishers? For that, we need a strong jurisprudential background. Please remember, even Kapil Sibal, very well-known advocate, he appears in number of cases relating to intellectual property. He appeared probably in Novartis case also, if I remember well. Can you say that he is an expert in IPRs? A stage comes when I think every advocate with lot of experience and insights into the other disciplines can also become a very good advocate of intellectual property rights. So having made these preliminary observations, I have a very small presentation. I'll be stopping at the last 2 slides. The remaining are quite routine. And when we are talking about importance of intellectual property, it is there for everyone to see. Now, in fact, this is one slide which I always share with all the participants in every presentation I make, because I think the statements are really impressive. Like, whether you can quote Lester C. Thoreau of, the Harvard Business Review fame, who published an article sometime in 97. Then you can quote Albert Einstein. You can talk about the National Intellectual Property Policy. Then you can also quote the Honorable Prime Minister. The point is very simple. We are talking about Make in India. Then we are talking about Creative India, Innovative India. Everything is related to intellectual property in different aspects. Then as far as the growing importance is concerned, these are some of the reasons. And today, I think without capitalizing or without commercializing, without monetizing the intellectual property, the national or international trade would not thrive. This is one important point. Recently, I had an occasion to look at the non-violation complaints under Article 64 of the TRIPS Agreement, which might be filed against countries like India, Brazil, South Africa, Cuba. Again, we talk about the international trade law there. And what exactly are these non-violation complaints? What is the possibility of some of the countries like US imposing curbs on countries like India under Super 301 or keeping it under the watch list? So there, my point is that while teaching or learning intellectual property rights, we must be good in understanding the international trade law aspects as well. So don't look at the intellectual property in isolation. Then knowledge industries, international trade, the technology and law. Now everyone is talking about GPT chatbot. The other day I asked it to compose a poem on idli sambar. It did. You can also check a beautiful poem for that matter. Who knows, tomorrow it might be composing a poem even on Nalsar Law University, IPR chair, Professor Anindya Sarkar. It might, if there are enough entries. And that is the fast pace as far as the technology development is concerned. Elon Musk now is considering a rival to GPT chatbot. That's the latest. So IP lawyer or IP practitioner or IP student or researcher must be thorough with these developments. We must provide a platform to the students in the classroom or elsewhere to understand or to keep pace with these latest developments. That is one. And as I already said, there has been a paradigm shift in the teaching of intellectual property. In the good old days, as I said, there was no, in fact, separate subject. We used to study it as part of some of the core subjects. This is one. At the same time, I mentioned about the contracts, crimes, even civil and criminal procedure. Even today, the relevance still remains. Then another one is Of course, only probably in the late 90s that we started, in fact, either teaching or understanding IP as a separate subject. Probably the triggering point has been the WTO TRIPS agreement. Without TRIPS, without referring to TRIPS, nothing can be done. Even if we are talking about intellectual property as a territorial, in fact, subject for protection. But since we have already signed, there is no question of going back. You can't understand the ownership of property or the patentability of inventions without referring to Article 27. So you have to, in fact, establish a nexus between Section 2 of the Patents Act about invention or new invention, whatever. Again, you have to look at Article 27. This is another important aspect. Then I mentioned about the lack of interdisciplinary nature of the intellectual property teaching. My experience has been that we have a wonderful course called MBA Technology Management. IPR is one of the elective subjects. Probably instead of IPRs, it should be IPM. But I found very few aspects of IP management in the syllabus. We are talking more about the intellectual property rights, the same thing, the concepts, then, literary property, industrial property, then the mechanism which is available. There is a need to, change. That is another aspect. Then, as I already mentioned, the transnational character of intellectual property must always be kept in mind. There comes the possibility or the need to study the international dimensions and also the comparative aspects, both. And since TRIPS agreement speaks only about the minimum standards of protection, there is a need, because if you are working for multinational corporation, you should know what exactly is the legal regime of maybe USA or under the European Union or in UK or any other country for that matter. So comparative aspects in view of the transnational character. Then IP teaching, as I already said, very unfortunately, let me share, a very rudimentary thing. Why the legal teaching has not attracted, or legal research has not attracted much attention in the conventional law schools or even centenary universities, like maybe, Mysore University, Usmania University or Banaras Hindu University, because of only one thing. They treat law as a social science. They don't treat law as a professional subject, as is done in the case of national law schools. So the focus will be, in fact, little blurred. Same is the case with regard to the IP teaching. So IP teaching also has not been focused for various reasons, because any person who joins a course on IP, whether it is one of the programs of World Intellectual Property Organization, the distance learning program is there. World, there is a particular wing of, WIPO Worldwide Academy, something like that. Yes, WIPO Academy. So DL 101, fine, that is a basic course. Anybody can study, but that is only the beginning course. We have to be focused. We have to specialize. Same is the case with intellectual property. And many people think that masters in IPR is like masters in labor laws or constitutional law. Not for the sake of degree alone. We need to learn more, in fact, important dimensions of intellectual property. So target group, of course, one very good question is raised by, one of the students. At their level, when they are students of undergraduate course, certainly what they can do is to build a strong foundation of all these subjects, not intellectual property alone, because they have to take care of the other subjects as well. But if you are good in contracts, if you are good in law of torts, or maybe the crimes, maybe the procedural aspects, or international law, including international trade law, over a period of time, you will certainly become a very good IP professional, be it a manager, advocate, practitioner, whatever. Then, what to teach? As I already said, concepts. The difference between a good teacher and good student is probably not hours, maybe minutes. If you have access to internet, within 2 minutes, the student will catch up with the teacher. Therefore, concepts are better understood by the students as well. But what exactly is to be taught? That is one aspect. Then what are the best methods of teaching? Purely, theoretical teaching is one aspect, but it must be supplemented by the practical aspects. And these are some of the good, attributes of teachers, but I will squarely apply it to the students as well. For example, sound jurisprudential knowledge. Many people tend to undermine the importance of jurisprudence, but IP jurisprudence is based on the traditional jurisprudence. Today, people are talking about monkey selfies case. People are talking about Dabas case, where, a patent was granted by South African, patent office, whereas the other leading IP offices rejected the same. We are talking about the legal personality of animals, legal personality of machines. Is it an entity or is it an instrument? For that, jurisprudential basis is required. Then interdisciplinary nature of IP needs to be understood, and that must be made an integral part of our IP teaching or learning. Then similarly, the correlation with the other subjects. Those competition lawyers, they are also good IP lawyers, as simple as that. And competition law and IP, they go together. No doubt, intellectual property confers limited monopoly rights, but we should know what exactly amounts to abuse of dominance. So you can probably contact Mr. Sukesh Mishra, who is in a very high position in Competition Commission of India. He will be in a better position to explain the growing nexus. Then another point is the other relevant factors, like the target group, like how to teach a UG student, then a PG student, then a researcher, then a diploma. Then another important aspect, I don't want to go into the history of IP and its protection because it's not the introductory class. Then in fact, the three aspects must be taught in the classroom. One is with regard to the creation of IP assets. This is very important. Like there was a criticism against the Indian policy makers as far as academics are concerned, that they are teaching about the intellectual property rights without explaining how to create intellectual property, how to manage intellectual property. They're starting with the last topic first, then they are coming to the basics again, later. That should not be the case. Then, after the creation of IP assets, the protection comes. See, the question is this. We are talking about creation of IP assets. Don't look at only the patents. Look at the other areas of intellectual property also. Patents are very important. I am not undermining their importance. At the same time, what about other forms of intellectual property? For example, take the case of Mr. Sanjay Tandon, Indian Singers' Rights Association, who has been working with the singers' rights for the last 40 years or so. Now the question is, he wants to protect the rights of the original singers. He worked with Lata Mangeshkar ji, he worked with many other stalwarts, music composers, and he was one of the persons instrumental in 2012 amendment to the Copyright Act, which has changed the scenario as far as the singers and the performers' rights are concerned, including the digital rights, digital copyright. One needs to focus on that because there is a lot of future in the entertainment industry, music industry, film industry, publishing industry. So equal focus must be bestowed even on the other forms of intellectual property. Then comes the management. So creation followed by the protection, then management, they may go together. That is also equally important. Assignment is part of the management. Licensing is part of the management. So without understanding what is a license, the difference between lease and license or assignment, franchisee, whatever it is, which are taught in some of the important core subjects, we can't be a better IP professional. This is another important aspect. So anyway, justification, I will not go into that. debate is going on. Don't look at only the commercial aspect of intellectual property. If Gautam Bhatia is appearing in Sci-Hub case as an intervener, is a leading constitutional lawyer, talks about constitutional morality and all, fine. But if he is intervening in the Delhi High Court, maybe, on behalf of not Sci-Hub, I don't know whether it is on behalf of Sci-Hub or maybe as an independent intervener. The point is very simple. There is a justification, right to access to get information and all. That is also part of the IP practice. Then, of course, UDHR, then the WTO, preceded by the Uruguay round, all those aspects I need not explain. Justification also, because sometimes the questions do arise. Is it everybody's property or anyone's property? IP student must know, in fact, the intrinsic value of traditional knowledge also. One of the members of, in fact, Niti Ayog, former members, Mr. Nirmal Sen Gupta, and in fact, he pointed out at a document prepared by the Britishers explaining the reasons for not having any famine in Gaya, Bihar, for almost 150 years. Then ultimately it traced it to the traditional knowledge in the form of, maybe construction of check burns or earthen banks, so on and so forth. So the student or the practitioner must also know about these aspects. This is one. Then these points are already taken up. Who are the target groups? Maybe, there are legal experts. They also need IP education. And National Judicial Academy also conducts regular programs for the sitting High Court judges, even on intellectual property. Then technical patent experts, they will also be undergoing the, refresher courses or the awareness programs on the emerging areas. Then enterprises and research centers, they are also equally concerned. Civil society also. So this is another important aspect. Question is this: what is taught is not really satisfactory. As I already explained, normally they talk about, the concepts first, then maybe the international regime, then followed by the national legal regime in respect of patents, copyright, trademarks, designs, GIs, finish, it's closed. But it may not really help in the emerging scenario. So what should be taught? Teach the concepts, the core aspects of intellectual property. Then we must also teach how the intellectual property must be managed, whether it is licensing or the other aspects like enforcement. International IP law also is equally important. And that is with regard to law experts. When it comes to the enterprises and research centers, again, for example, T-Hub, Telangana Hub, it is one of the flagship initiatives of the government of Telangana. We have T-Works, T-Hub. Now they are trying to focus on intellectual property rights. And in fact, IP are awareness programs and certain special programs to train the entrepreneurs on this particular aspect. So valuation of IP assets. I keep on, in fact, teaching my students about how Charminar cigarette logo, Charminar logo itself was one of the securities for creation of a loan, raising a loan about, I think, 100 crores or more than that. That's a point. That's a point. So we have, other aspects like how it should be taught, curriculum structure of intensive courses. I think our curriculum needs a thorough revision because the best practice in the law schools or universities is that every 3 years or so, there must be a change in the curriculum. And in some of the law schools, at least one unit is kept open. Every year, it is the discretion of the teacher, the demand of the students to have a fresh syllabus, at least for one unit, if not for all the units. This can be taken care of. Then, as I already said, the courses could be, in fact, domain specific. Like Nalsar has patent law and practice, advanced diploma in patent law and practice. IGNO also has a wonderful program with lot of, standard literature which is supplied. It could be, focused on a particular aspect. Biotechnology patents. So, WIPO Worldwide Academy conducts a program on the digital copyright, biotechnology patents. If we stop at DL 101, the matter is closed. We should go beyond that. This is another important aspect. Then industry-specific courses, whether it is, the computer software, patenting of computer software is a program. If you look at NIMS May, the, Micro, Small and Medium Enterprises Institute of Central Government, it conducts regular programs. Same thing can be done in the universities. Or maybe NIPER, we talk about the pharmaceutical intellectual property rights. So they are more concerned about how to protect the intellectual property created in the field of pharmaceutical field. Then there are others like internet law. It can be having a nexus with the cyber laws as well. Then we also have cross-sectional courses, interdisciplinary courses. I already mentioned about IP management, IP valuation. Then how should it be taught is another important aspect, which should be pondered over by the stakeholders, especially by the universities, the law schools, the academia, right? So this is very important. Without understanding the contents of specification, how can you understand what is a patent? What should be written as part of the claim? Take the case of Dr. Kalyan Chakravarti. You must have read some of his books. He is a leading IP practitioner. And he writes in his fun IP, he writes novels on about, on the intellectual property rights. But he is an expert in drafting of specifications. And I think these specifications, when they are drafted in a systematic manner, they are chargeable. And whether his experience in Franklin Pierce Institute Center or elsewhere, but everyone cannot be Dr. Kalyan Chakrabarti. We should know what are the contents of the provisional specification or complete specification, what are the claims. I think now we have greater access to all these things in the public domain in respect of the patents which are already granted. While studying intellectual property in the law school, we must get exposure to these practical aspects. So we have to focus on drafting of the patent claims, patent applications, then drafting of license contract clauses. People talk about corporate and securities laws as it is a Brahma Padartha. People think that it's the most important thing. But are we teaching IP related aspects in that? The contracts relating to intellectual property, how to draft a licensing agreement, an assignment agreement. This is another important aspect which can be taught. Negotiation of license agreements, pre-trial infringement litigation, mock trials, moot courts. Why not on the intellectual property related problems? Why only on, whether Section 377 IPC should be decriminalized? Why not on intellectual property rights also? That is also equally important. I am not, diluting what Section 377 says or said. That's a different issue. Similarly, internship in law firms. Professor Sarkar is very particular about his students getting internship. But the law firms also can provide intensive internship. Maybe for a week, maybe for 15 days, maybe for a month. But where the students get an opportunity to work on the practical aspects. Let them learn only about the specifications. Let them talk about the licensing agreements. Similarly, we have, in fact, an initiative of NIPO, National Intellectual Property Organization. Professor Unnat Pandit, recently he came out with an initiative to have a panel of experts who are ready to share their knowledge free of cost throughout the country. They started the registration just, about 2 or 3 days back. NIPO. Similarly, IP management firms. The another one is supervised research papers. An original paper can be made as part of the curriculum so that the student gets an opportunity to look into not only the theoretical aspects, but also the practical. Then another one is publications. Some of the best universities in India like Nalsar, they have an exclusive journal on intellectual property rights, Nalsar Journal of Intellectual Property. So we have so many such platforms. The standard publications are always encouraged. Then case method of teaching, again, versus the problem method of teaching. One of the examples could be patentability of the inventions, whether a particular invention is patentable or not. On that, there can be these two different kinds of teaching. Then international and comparative law approach. For example, you are talking about computer-related inventions. Sir spoke about the AI created inventions. We are talking about CRI guidelines, maybe Farid Alani's case of Delhi High Court. Then before that, number of other cases decided by courts like US Supreme Court, Bilski versus Capos, and many others. There can be a comparative study. Then continuing education. Here the point is very important. IP teachers are not Mr. Know-all. IP teacher also must undergo frequent training, frequent updation of the knowledge. So continuing education, as Professor N.R. Madhav Menon used to say, there is a need of continuing judicial education. And now we have to say that there is a need for continuing education for teachers, and not in the form of just certificate, 1 week program, 15 days program, refresher course or orientation course. It must be more scientific. This is another one. So we can facilitate by various means. And now comes, in fact, the basic question which is posed by Professor Anindya Sarkar. Is our IP education churning out the needed talent? I would say emphatically no. We need, in fact, better IP professionals. We have some of the professionals who are really good. With great respect to them, we can, in fact, produce better IP professionals. How can it be done? One example I try to give in the form of Rajiv Gandhi School of Intellectual Property Law, but since it is an academic platform, let me say that it started with a great promise. I don't know whether the promise is still kept or not. There appear to be certain gaps. But still, they try to correlate various laws. Look at their website. They teach biodiversity law, then its implementation, bioenergy IP, comparative competition law, then information technology law, innovation and business incubation. So all these aspects must be made an integral part of the curriculum. This is one important aspect. Conventional universities, they have their own, in fact, weaknesses. But I think they are doing good work, at least in some of the universities. It may be like Cochin University of Science and Technology, and maybe, even in Usmania, Andhra, and many other universities. But again, it is the enthusiasm on the part of the students, on the part of the teachers or researchers, which makes all the difference. Then some of the national law schools, or maybe including Jindal, University, they have specialized centers. Like we have, in fact, Center for Intellectual Property Rights Advocacy in National Law School, Bangalore. There are a number of IPR chairs. I'm very happy that Nalsar IPR chair has taken up this wonderful task. Then in the foreign universities, of course, the approach is a little more professional. And whether it is Franklin Pierce Center for IP at University of New Hampshire, in fact, most of the IP practitioners, they used to go for this particular course in the good old days. Even now, I think that there is a steady movement from India to those centers. Sometimes even Max Planck University also in Germany. What I'm trying to say is that a good beginning has been made, but lot of flexibility needs to be introduced in the teaching of intellectual property, and the basics certainly must be focused, but at the same time, the management aspects of intellectual property, the enforcement aspects of intellectual property, patent agents, see, again, they are supposed to be graduates of science, engineering, and technology. What about lawyers? I believe there is some case pending in Chennai High Court to enable the lawyers also to take up patent agent exam.
The provision was there earlier.
It has been removed. In fact, intellectual property used to be under the control of chartered accountants for a long time. before lawyers took over. Fine, but lawyers are kept at a bay even today with regard to patent agents exam. Lawyers with their legal acumen, they are trying to, declare that particular rule as void. Be that as it may, ultimately they can't escape from the lawyers. Patent agents have limited role. Associated legal advice is rendered by them. But when it comes to the lawyers, again, they take over once the matter enters the litigation stage, once it is out of the, controller's office. And let me tell you, the pathetic situation in some of the schools. It was a confidential work, an assignment in Delhi. I was sitting there for 3 or 4 days in an interview panel. And the position is a very important position in the IP administration of India at a particular level. Most of the candidates, they came from 2 or 3 areas in Uttar Pradesh, very few from maybe, the other areas. And you will be surprised to know that most of the candidates were lacking even the basics. But still they appeared for the interview, with great respect to them. And then I was lamenting about the lack of professionalism in teaching intellectual property rights. And that is what is needed right now. And I sincerely hope that these are the changes which would be required. Curriculum must be changed, certainly. Teaching and learning, practical aspects also must be taken care of. This is equally important. How the curriculum must be changed, I think we already discussed. The emerging areas. Now artificial intelligence must be taught. And deep blue also must be referred to, which defeated Gary Kasparov. Maybe, of course, with human assistance, that's a different issue. Then similarly, we have life patents. Don't think that they have become irrelevant. Their importance is still growing. IP in metaverse, there are a number of issues relating to non-fungible tokens and all. Then there may be IP issues relating to even cryptocurrency also, if we probe further. So all these aspects, whether it is business methods or other related aspects, they must be made an integral part of our IP education. Then, as I spoke about the interdisciplinarity, IP is intradisciplinar and interdisciplinar, both. So when you look at the management, IP management aspects, the, in fact, economics related, technology transfer, innovation, all those things must be taught. And without, increasing the burden on the teachers and students, it can be ensured. That's one important aspect. Teaching also, as I already said, at least, one component must be totally on practical aspects. The students can be encouraged to go to R&D institutions, maybe IP law firms, or maybe, IP offices, or maybe some of the line departments and, other authorities to work on the practical aspects. Nothing wrong in working with, Sanjay Tandon, or working with, Shah Rukh Khan also, so long as it is relating to intellectual property. This is another one. Then even WIPO, Traditional Knowledge Digital Library, they are good, very good, working examples where we can go for hands-on approach. This is another one. So practical aspects. Let the students file at least one application. People have a very low opinion about some of the rural universities, which may not be correct. I have seen rural students applying for a GI tag for Nizamabad country chicken. It is the students of Telangana University, very small university, hardly, with about 40 or 50 faculty members. But it is the students who took initiative. The matter is pending today. Somebody got a GI registration for Tandoor red gram. Subhajit Saha was there in the forefront. Now, recently I arranged a lecture because he is the one who ensured that it was granted. He pursued it. Take the case of Hyderabadi Halim, Mr. Ravi of Rights and Marks, again Hyderabad-based IP lawyer. He did a wonderful work. The question is, why not our students are associating with such people? and filing at least one GI application, one trademark application, one copyright application, so that they will be coming out of the law school with lot of practical experience. Then MOUs also may be there, for example, for faculty exchange or student exchange between various academic institutions and other institutions. So I think we need all these things to make our intellectual property education more relevant, customized to suit the needs of the different stakeholders. So these are some of my stray thoughts. I only hope that I have not deviated from the topic given to me. If you have any clarifications to seek or comments to make, over to you. Please repeat.
Okay, sir, can you hear me? Sir, as we knew from the presentation and from whatever you taught us in like last 1 hour, that how important it is in our schools and also our university to educate about IP. Because I have also like passed out last year only. So in my college, there was no subject for IP. So even though we were from chemistry department, but there was no subject for IP. But then when I started working, I understood that how IP is important. So we know how important it is, but then when it would be inculcated in the teaching regime, so the students would know that how important it is in professionalism as well.
Good question, because especially for the students coming from a non-law background, there is a gap to be bridged, and this can be done either formally or informally, either at the initiative of the student himself or herself, or at the instance of the institution. Maybe one can enroll oneself in one of these short-term courses to get acquainted with the particular area, or else the universities may design a bridge course for a few days, maybe 2 weeks, 3 weeks. A primer kind of thing can be prepared, shared and discussed, and a certificate also may be given. It will serve both the purposes. One is value addition course, the second thing is whatever is the knowledge gap that will be filled. And the universities have a lot of autonomy and flexibility in this regard. They can do so. They don't require anybody's permission. Like for foreign students, we do that in the case of English, because most of them come from Arabic countries. They are not so good in English. So we make them enroll themselves in a 6 months course in our English language teaching center. So after 6 months, they are as good as any of the other students. Here also it's not the same, because you know something about the intellectual property. You have a lot of interest in that. But to formally understand, a bridge course would be the best bet.
Thank you, sir.
Good. There appear to be no comments. So thank you very much.
Thank you so much, sir. I would like to invite Professor Sirkar to once again give the memento. Thank you, sir. Now for the much-awaited quiz that Professor Sirkar would be hosting. I think we are all very excited about it, and without further delay, I'd hand it over to Professor Sirkar to take over. Thank you.
So this quiz is for everybody. Everybody will participate, and using your phone. And those who are having a weak signal or weak data plans, our group will give you access to the Wi-Fi here. And see, I will tell you the rules of the quiz. It's very simple. This is the award which we are giving for the quiz. And everybody is invited. Now you will be. So everybody has a internet access. Fine. So there is to keep it more. See, I usually don't do this, and I normally speak. As a teacher, I love to teach. I love to give public speeches, but we thought for the first time we'll do this, and maybe it's a stress buster. In between we'll try to reduce the stress. Uh, Shubhi, you want to participate? Yes, you should. So your answer, you only will know, okay? We are not going to say who was the right answer, who was the wrong answer. At every stage, I'm going to show you 10 leaders. Okay? And you will have 20 seconds to answer. Okay? And this WeShare, this is for connecting my laptop to the screen. Okay. Now, you can either scan it or go to this website, enter the passcode, and we are all in the quiz. And let me tell you one thing, write your proper original name, not your Facebook name. Then we can't give you, even if you win, it will be a loss. So, let me know when we are done. I just have only 16 people who are logged in. Hmm? Ramji trying. So go to menti.com and just enter that passcode, enter your name. We have about just 28 people who have logged in. Study. स्टार्ट नहीं किया स्टार्ट नहीं किया मैं स्लो इज नेट कनेक्टिविटी देन check. Yeah. Are we ready to go? So each one, please enter your name, and one of those emojis have been allotted to you randomly. Are we all in? See, the questions are very, very simple. Okay, I thought it should be a fun time. Okay. This is also part of IP education. Are we good to go? We have 45 players. Remember, you can click your answer only once. You can't go back. You will have 20 seconds for each answers. They are all multiple choice. And I have also introduced the fastest finger first. So here's your first question. Who is the current Controller General of Patent Design and Trademark in India? And the option are Arjun Pandit, Unnat Pandit, or Unnat Singh. 40 people have already answered, 41, 42. Your 20-second is over. It's very surprising that he was the chief guest of today's function. And then still, maybe, some of the guys are too influenced by Sunny Deol's Arjun Pandit. And let's see how we stand. So Monica is leading with 971 points. She was the fastest, followed by Ayush Bajpayee, Vijay, Aditi. We'll only focus on the top 10 here. And as we move forward, we'll be adding the points of each question so that you can improve on your fastest finger. You can also improve on the right answers. Okay? Okay, Karthik is also there in the list. Oh, Mani is also here. Good. So your next question is, intellectual property right protects the use of information and ideas that are of ethical value, social value, commercial value, moral value, or sentimental value. Second over, 38 people says commercial value. There were a few social values and ethical values as well. Now let's see who are the guys who answered this first. Ayush Bajpayee was earliest. Now let's add those points to the previous. We see this leaderboard, this results key is very dynamic. It keeps on changing. So Vijay is now on the top. Vijay, Ayush, Christopher, Nitya. But the difference is not very high, 1907 and 1895, those are just a click. So I suggest that you look at the answers here. What does WIPO stand for? World Intellectual Property Organization, World Intellectual Program Organization, Worldwide Intellectual Program Organization, World Intelligence Property Organization. Jaldi for and so 36 people believe that WIPO is World Intellectual Property Organization. Let's see if this has made any difference to our again, Vijay was the fastest, followed by Christopher, Nitya, Karthik. Let's add it to the previous. Yes, Karthik is now leading. Where is Karthik? Ah, right at the back. Vijay Aditi Singh. Okay. The difference is not much. Vijay is just few points below. So let's move on to the fourth question. Patents are granted for novel products, process, both products and processes. Both products and processes. And let's look at the results. Karthik was fast this time also. We add those points to the. See, Vijay and Karthik difference is one. Some millisecond difference. Let's go to the fifth question. The term of a trademark is 10 years, 20 years, 50 years, perpetual. There goes the 22nd. The answer is perpetual. Only 7 people got it. You can renew a trademark every 10 years. Okay. And let's look at who are those 7 people. Saurav, Suryamani. The teachers have now come in. So Saurav is now leading, followed by Suryamani. So let's look at the next question. How long do patents usually last for? 10 years, 20 years, 40 years, 60 years? Twenty years is the right answer. About half the people got it. And let's look at, does that change anything in our leaderboard? Again, Saurabh Suryamani is still on the top. But again, the difference is very, very minimal, so you can, Suryamani should give it a try. We are halfway, and the seventh question is, which of this is a geographical indication? BMW, Champagne, Hogwarts, PlayStation, World Wide Web. It is Champagne. I thought everybody will get it. But we have some Harry Potter fans as well. And let's see if that has made any change to our. Somehow the top 5 is not changing, which is a good sign. Saurabh, Suryamani, Sejal, Vijay, Vivek. Let's look at the next question. PCT is mode for grant of international patents. True? False? Huh? That is quite a bit of embarrassment. There is no international patent. It doesn't say application. PCT is a mode of filing patents, not a granting one. So only seven guys were right. Yes, money is now. Surya has overtaken Saurabh. Now we have a new third position, Bhargav, Sejal, and some Casper. So our ninth question is, can a lecture delivered by an academician be reported in a newspaper? Yes, with permission. Let's see if that has made any difference to our leaderboard. Surya is about 1,000 points above. So our 10th question. Guys, you are enjoying it or not? Having fun? Hmm? That is chargeable. International copyright is governed by Paris Convention, TRIPS, Berne Convention, WTO. Here goes your 22nd. It's Berne Convention. About 20 people said Berne. Some people believe. So whenever we can't understand, we blame it on TRIPS. Any confusion? TRIPS नहीं किया होगा. So let's see how. So again, you have Suryamani, Saurav, Sejal, Vijay, Nitya. We are Shubhadeep is becoming a challenger. So let's look at the next question. Which term refers to software that is distributed for free with accessible source code that can be modified and improved by anyone? Freeware, shockware, open source, closed source. Open source, most of the people got it. See, the answer itself was suggested. Now, with this question, we let's look how the leaderboard has changed. What rubbish is that now? So this question, the quickest answer was actually from Saurav, then by Suryamani. So that makes our current score, the leader is, I think, Dr. Suryamani Tripathi is becoming unbeatable. It's followed by our Professor Saurav, then we have Sejal, Vijay, Shubhadeep. Now, let's look at the 12th question. Be fast. A provisional specification is filed to fix expiry date, assignment, term, priority date. Some of you are not answering. There are need to be quick. Your 20-second ends there. 24 people responded saying priority date of the patent. The next highest was the assignment of patent, followed by expiry and term. The right answer is priority date. And I'm sure in your phone you are getting all the right answers also. Now, do you think Saurav was able to overtake Suryamani?
So I don't think I will. Because I got one wrong, so I don't think I'll be able to bridge the gap.
Okay. Let's see who was the fastest. Suryamani was even this time. So again, it's led by Suryamani, followed by Saurav, Sejal, Vijay. Guys, you still have some time. This is the prize. This is the prize. It'd be wonderful to keep such a thing. So we have two more questions left. Let's look at the 13th question. Name the inventor who filed a patent caveat for the telephone on the same day Alexander Graham Bell filed his application. It is Thomas Alva Edison, Marconi, or Alicia Gray. All 47 have answered, 20 seconds over. The right answer is Alicia Gray. 9 people got it. Was it by chance or you knew it? By chance. So, did anybody know that answer? All 9 was by chance. All by chance. So you'll. So, I mean, that's the fun, that's the excitement which should be there. It is not the right answer or, being part of such a. This is the first time I'm experimenting with this. If it works well, we'll have proper programs for this. And my software can accommodate up to 2,000 people. One shot. So let's see if Saurav is. Suryamani was still on the top, followed by Saurav and Bhargav. Then we have Sejal. The last question. Okay? Here it goes for you. Patents are prohibited for traditional knowledge, arms, atomic energy, junk food. except one, all I've already answered. The answer is atomic energy. 18 people got it. Not traditional knowledge or. So what's your guess? You think Suryamani is still on the top? Aha! Aha! All hope is not gone. Hold yourself. Let's put those points. So the winner is Suryamani. Runner-up, I will personally give prize. So that was I think enjoyed it as much as I did. So give one more round of applause.
Not fair, not fair. Let the IP people be.
Well done. I would have been, I'm not happy with it.
I've given a 2 round.
So, I would have been happy but
I am also a student.
but no longer. He's also from that I So I hope all of you enjoyed it as much as I did. And we'll have more of such events, more some graphics, more analytics building. Okay. So there's some suggestion that we should have separate for students, separate for, no, this is an open program, so everybody can participate. Thank you very much. So I think we will try to work out in such things even remotely. You can sit in your home and, press your phone. Ah, virtual. Virtual. Amazon coupons. Thank you very much for being with me for this small little quiz. I think she has some.
Thank you, sir. I think we can break for lunch for an hour. And lunch is at the mess for the participants and at the CC for the speakers. Thank you so much.
You showed a picture of.